Good morning, everyone, and welcome to Finance on the Blockchain. I'm the CMO of Arca, Simona Matra. We're excited for you to join Arca and all of our wonderful partners this morning. The idea for this conference came last year when we realized that interest around tokenization, digital asset securities, and infrastructure was increasing, but there was a lack of concentrated educational information around these topics. Arca and our partners decided to come together and create a full-day educational event that focused on the most frequently asked questions that we received over the past year. Every one of our partners are committed to helping educate the public on digital asset securities, so I strongly encourage you to get to know our partners who are listed on our welcome page. One more comment before we begin. Often in the media, we see sensationalist headlines that Bitcoin is going to take over the world or that crypto will eventually replace all fiat currency. These headlines are much more about crypto replacing the current financial system instead of working within it. You'll see the digital asset security space is much more careful and takes a much more careful and measured approach to digital assets. We here at Arca refer to this as responsible innovation. We're not here to disrupt, but instead enhance and improve. This means that we're taking the best of what the financial system has to offer and blockchain technology to create a new financial paradigm that works within current workflows. That being said, I would like to introduce our first keynote of the day, SEC Commissioner Hester Peirce and former SEC Chief Risk Officer and current attorney at Holland & Knight, Gabriel Benincasa. Please welcome the two of them to the stage. Thanks.
Hi. Good morning, everyone. Hopefully you can hear me. Let me just kick off this session by giving you a little bit of background about myself, and then Commissioner Hester Peirce will talk about her background. So I recently joined Holland & Knight as a partner, and I'm leading our efforts in digital assets. Right before that, I was the first Chief Risk Officer of the SEC, where I had the pleasure of meeting and working with Commissioner Peirce. I'm an attorney and CPA, and I've done legal compliance, risk, and audit. That just goes to show you I cannot hold down a job. Right. I actually started my career, and if I had time, I would go into more depth, as a watermelon farmer, which is currently my retirement plan, but it's more for consumption and not the tokenization. So let me turn it over to Commissioner Peirce to introduce herself, and then we'll begin the event.
Thanks, Gabe. I don't have such a colorful background, but I've been a commissioner at the SEC since January 2018, and I'm very much looking forward to the conversation this morning. I appreciate the opportunity to be part of today's conference. I think you've got a great lineup ahead of you. And so looking forward to kicking it off with this discussion. I do have to give my disclaimer. I should not forget that, which is that my views represent my own views, not necessarily those of the SEC or my fellow commissioners.
Just to, as we begin, we just wanted to level set and get your thoughts on the definition of a security, digital asset security, and a digital asset. So this way we can all be on the same page as we begin.
So you, of course, start with a very hard question. I think there has been a lot of discussion in the last several years around where those definitions fall and where they intersect with one another. So a security is obviously a very broad concept and encompasses lots of things, and that's why many things that are digital assets may fall into the security bucket. I think there's a potential for the field to grow even broader. I mean, I think we'll ultimately see that most securities do become digital, just for convenience purposes. I think that will happen. But at the moment, there's a lot of uncertainty around how the SEC is thinking about digital asset securities, and even within the SEC, you see some different points of view, including my own view, which is that we're sometimes thinking about the token as being the security when actually it's part of a broader securities offering. It's part of an investment contract, but the token itself might not be properly considered to be a security, which is one of the reasons why I proposed a safe harbor, which would allow people to kind of not have to make that determination of whether a digital asset is a security at the outset, but would give a 3-year trial period. Trial period isn't the right word, but a 3-year period during which certain information would be provided. The anti-fraud laws would apply, but there wouldn't be an official determination made as to whether something was a security until you were at the end of that period, at which time the network might be so decentralized that it wouldn't make sense anymore to provide securities-like disclosures, because there would be no one party that had more information than another.
Okay. In the recent release by the SEC, they call for the separation of a digital asset broker-dealer for custody purposes from other activities of that broker-dealer. What are your thoughts on such separation? Could it add more risk? Do you think that's the proper approach to allowing the special purpose broker-dealer to operate for digital assets?
Yeah, so a year ago or so, we put out this special purpose broker-dealer relief, which had been a long awaited relief, and it was quite constrained in the sense that, as you mentioned, it sort of envisions the special purpose broker-dealer dealing only with digital asset securities, not securities and not other digital assets. And I was concerned that would be quite constraining because, for example, you couldn't have that would prevent Bitcoin and digital asset securities from being held side by side, and that seems quite impractical. But it was a baby step, and that's positive. I think firms have been working their way through the process, but my suspicion is that we're going to need to provide additional relief to really accommodate the real world kinds of things that firms in this space are trying to do. And so I think that really has to be just step one. I think there's a lot more work to be done.
Mm-hmm. Being a former compliance officer, the reason why it's kind of concerning is how do you deal with constantly monitoring? And if you follow kind of the rationale of the Hinman letter, how do you follow if something goes from being an original security and then gains such wide acceptance that it may no longer be a digital asset security? And, as part of the release, you have to have policies and procedures. But besides the policies and procedures, my concern is how much it's the monitoring, it's the constant compliance, and the risk that adds to the system. Could it be dealt with in a better way? Because just how we currently comply with 15C3.3, you have to segregate the assets, and so so to me, it adds an operational risk component that would be very difficult to constantly monitor. And who's to say, so at what point in time, what is that day that something ceases to be a digital asset security and is used more for consumption?
Yeah, Gabe, I think you've put your finger on one of the real difficulties, which is the uncertainty around when something will be considered a security and for how long has made it really difficult for people to use this relief and to do other things too. I mean, platforms trying to figure out whether they can list a token are always trying to ask the question of, is this a security? And maybe if it was sold as a security once, is it still a security? And that's why I think it would behoove us to as an agency to release some kind of guidance so that people could try to figure out where things fall. Now, we did put out, or the staff did put out some factors several years ago by which one could analyze where something fell, but there were a lot of factors, and there was little guidance given about how to weight those factors. And so I think this has been a constant struggle. And then when we do bring enforcement actions premised on the idea that there have been some securities involved, we don't tell people which digital assets we deemed to be securities. So there's a lot of frustration out there, and I think it's warranted that we're not doing the job that we could be doing on the regulatory side to try to put some more parameters around this. Again, it's not standard practice for the SEC to go out and identify things that are securities and things that are not. But I think in this space, there's given the ambiguity, I think it would make sense for us to try to be a little bit more proactive on that front.
Mm-hmm. Yeah, I think you kind of good segue to kind of my next question is, when you look at most recently, the Department of Justice has made it clear that they will really regulate through enforcement. And although the SEC hasn't been that clear with some of the actions it is taking, it has kind of shown that it's really may regulate through enforcement. And when you don't have clarity as to definitions, it really puts, the companies that are involved and the gatekeepers. And I was just at a presentation where, Chairman Gensler made it clear that he'd like to, gatekeepers to, hold them liable. But we're in a situation where, without guidance, how do we follow? Do we just rely on a 1946 case? We do as an industry need guidance, and it's a incredibly growing industry, and it's fascinating, has incredible potential. But without guidance, I think it puts us all at risk. Thoughts on that?
Well, yeah, I mean, I should say that I certainly can't speak for the Department of Justice, but the one important distinguishing factor between us and the DOJ is that we are a regulatory agency. DOJ is a law enforcement agency. So we're primarily a regulatory agency. We do have a law enforcement function, but it's ancillary to our regulatory function. And so my view has been that, you try to set forth clear rules. Most people are looking to know what those rules are and then to comply with them. If people don't comply, then you move to an enforcement action. Now, one of the difficulties, of course, is that our rules are not, you don't want to write rules that are so prescriptive that you have to change them all the time. You want to have principles-based rules. And I think that that's what the drafters of our securities laws tried to do, is draft rules the laws and then rules under that that would stand the test of time. The Howey case, which you referred to, is one that interprets what an investment contract is, which is one kind of security. And that test, which is now quite an old test, has been applied in a lot of different circumstances to a lot of different types of things. And in some ways, it's a very practical test, right? You give someone money, part of a common enterprise, with the idea that the person is going to do all the work and you're going to get a return. The person's promising you a return solely based on that person's efforts, not on your own. That does look like a security. But the problem is that applying that Howey test can be quite difficult, not only in the digital asset space, but certainly in the digital asset space. And so I think it would make sense for us to think, what are the objectives that we're trying to achieve, right? What are the objectives of the securities laws are to make sure that investors have the information they need to make decisions. And so why don't we take a look at whether the types of disclosures that our securities laws would demand are the right types of disclosures in the digital asset space? Or is there another set of disclosures that makes more sense for someone who's buying a token? And if there is, why don't we draft that? Why don't we require that set of disclosures to be made instead of saying, no, you have to fit within the boxes that we've designed under the traditional securities rules and laws. So I think that's certainly what I would like to see us do is provide that regulatory clarity and then use enforcement as needed to go after people who aren't complying with the rules that they understand and know. It would actually be helpful from the perspective too of trying to sort out the bad actors from the good actors, because right now, because there's lack of legal clarity, it's much easier for the bad actors to hide.
Yeah. No, to me, I agree with you fully on, maybe we need a different regime, and, we may not be able to fit into this old style regime, and getting more clarity. And I think something else that we've discussed is, this is it's gotten so much attention. It's brought in so many new investors. It's actually brought in a lot of, I think, young investors. And, we are in a point now where if people can invest in the United States, it's very easy to go offshore. And at such point, so are we leading some of these investors who we are trying to protect into foreign markets, because we are not allowing, some of these industries to grow, like not allowing like a spot ETF. So are we really pushing some investors now to overseas markets, which may offer 50-to-1 leverage, but have no ability for anyone to hold them liable? They may be in a non-extradition treaty country. What are your thoughts on, are we pushing these investors abroad?
I think certainly some projects are avoiding the U.S. They're not coming here to build things, and they're not looking for U.S. People to participate in what they're building, and that's a shame to me. It isn't surprising that a regime like ours, which is much more, it has a long history and is more developed, takes a longer time to turn and accommodate something new. But I think we are risking losing real innovation and cutting off our U.S. citizens from opportunities that they would otherwise have by making it really difficult to do things here. So that really is a concern. And then you mentioned the spot Bitcoin exchange traded product, which has been something that I've been thinking we should have green lighted a long time ago, and we're still not green lighting these. Of course, approval of these kinds of things depends on the facts and circumstances, but I think we've gotten applications that have presented good facts and circumstances, and we continue to say no. And that is it's unfortunate, because we are depriving investors of access to a product that I think a lot of investors have expressed an interest in having, and might actually be a preferable approach to getting access to Bitcoin, to getting exposure to the spot price of Bitcoin, than some other products that are available. And so it does end up harming investors if you only think about investor protection from this one-sided view that we have to make sure that people don't get hurt. You also have to make sure that people have the opportunities that they want to have. Now, of course, you have to wrap that all with warnings to people that they need to be careful. They need to think about their own facts and circumstances when they decide whether to purchase any product, and that there is a responsibility on the investor to do some due diligence before buying things. But I think we too often at the SEC forget the investor opportunity piece of investor protection.
Yeah. It seems as though, we don't pay as much attention on the promoting the fair and orderly markets, as opposed to just protection of retail investors, two of the missions of the SEC.
Yeah, I mean, and I will say that, in defense of my colleagues who might take a different view, I think they would argue that indeed they are concerned about promoting fair and orderly markets, and they're concerned about crypto's volatility, which inserting that, bringing that into our traditional financial markets does carry with it certain risks. And so those are fair questions to be asking. People need to be thinking about the risk to the system when we do see new products and new services coming into the marketplace. But we can't let that fear paralyze us. We should take a clear-eyed view. This technology offers new possibilities, new opportunities, but And there's certain advantages that it presents to a regulator from, ease of regulation, because you've got the blockchain and it's easy to see what the history of transactions is. And you can build into code all kinds of things. So there are advantages to the technology. There are also things that make it much harder for regulators to deal with. For example, decentralized finance that is truly decentralized doesn't have the centralized intermediaries that we're so used to dealing with from a regulatory perspective. So I think having a clear-eyed view of the positives and the negatives would allow us to be better regulators. Too often, though, we get caught up in these narratives, bad narratives about those dangers without really thinking, constructively about how we can build a regulatory framework in which it can grow up in a healthy way.
So countries such as Canada allow a Bitcoin spot ETF. I believe other countries as well. And is there something that the industry can do together, or maybe to try and help get approval for a spot ETF? Do you see anything that the industry can do?
Well, the SEC has now issued quite a few denial orders in which kind of the thinking is laid out. And one of the real points of focus has been, is there a market of sufficient size with which there's a surveillance agreement? And so that seems to be the focus. And I think the focus, Chair Gensler has been pretty outspoken, saying that he wants to see crypto trading platforms register. And so I guess that would be one path. Congress might take a different view, that maybe they don't want the crypto trading platforms registered with us. That they may decide that they want the CFTC or some other regulator to be in charge. We did greenlight a futures-based ETF, which I think Chair Gensler, points to the fact that that ETFs are regulated under the Investment Company Act. So there's this investor protection angle to it. And the futures markets are regulated markets that are much more similar to the markets we're comfortable with than spot markets. But as I've said multiple times in the past, I don't understand the rationale that we're applying here. It seems to be a very crypto-specific rationale. It seems to be different than the rationale we've applied to past products and commodity-based products. And it's quite frustrating to me to see that we continue to double down on it in light of, as you mentioned, the experience that other countries have, which should give us even more comfort. I mean, some of these products are trading, they're trading a lot, and they're very popular products in other countries. And so we have experience with how these actually work in practice. Their rules may be slightly different than ours, but at least that's some evidence for us that these things can trade without posing problems to the market.
Mm-hmm. Any thoughts if before all these platforms became exchanges, or if they stayed in the format they are today, if somehow they formed some kind of consortium where data could be provided to a third party provider who could then do some market surveillance. You may not be able to get 100% of trading, but maybe you get a significant portion of trading voluntarily provided, so that you can have a market surveillance system on a kind of an industry-led basis as opposed to government-led basis.
Yeah, I mean, I think people are thinking about those kinds of options. Having some kind of self-regulatory organization is sort of a variant of that option as well. Maybe would have a little bit more of a role than the one you're talking about, not just a data collector, a data aggregator, but also setting some ground rules. So that's a possibility. I mean, I think certainly there are groups that are aggregating data now, and I think that as the market matures, there'll be more of that, and that can can give some comfort. And these marketplaces are they have an interest too in policing themselves and showing that they're not havens for manipulation as well. The Bitcoin market is a 24-hour market. It's a little different than our equity markets. It's there's a lot of arbitrage going on, and so when people talk about manipulating the market, you would have to manipulate a lot of markets, and also arguably you'd have to manipulate the futures market too. So I think there's some protections built in place, and that should give us some comfort. But maybe the kind of data that you're talking about, the data aggregation that you're talking about, would give us additional comfort as well.
Okay. I constantly get asked questions, and I'm sure lots of others get asked questions where we get these proponents saying we want to democratize financing, specifically with respect to expensive items such as commercial real estate, expensive real estate, art. And they would like to issue NFTs. And I know you just yesterday you issued a release calling for guidance with respect to NFTs. There's a number of potential issuers out there who think that they're not securities, but they have to go through a complicated analysis. So what are your thoughts on the democratization of for investors and being able to invest in expensive investments which before they didn't have or would not have access to?
Yeah, I think the technology allows for all kinds of interesting experiments with giving more people access to asset appreciation from all different kinds of assets. And that's exciting, I think, to me, because I'd like to see more people participating in the markets in general. 2021 really was a really big year for NFTs, and I think kind of fun to see people who aren't native to crypto being brought into crypto. Fun to think about the ways that NFTs can enable creators to benefit from their creations, whether it's writing or art or music, and so NFTs are a way for that to happen. Then the question becomes, do these things become financialized, and do the securities laws start to apply? And when people start fractionalizing and using these assets in financing arrangements, then those questions are real questions that I think people need to be thinking about. I'd love it if the SEC were to, take a step out there and say, look, here are some of the things that we're thinking about when we look at NFTs, and that maybe you should think about, so that people will have the heads up that these are areas they need to think about. We could do the same thing with respect to DAOs, which are also having a moment now, and I think it would be helpful for us on the front end to be thinking about some of those potential interactions with the securities laws. But unfortunately, that hasn't been the way that we've approached most of this area. So I wandered a little bit away from your initial question, which is this a good way for people to get access to assets they might not otherwise? And I think it does really pose some interesting opportunities to allow people to participate in all kinds of marketplaces.
Mm. Yeah, I wonder if the Congress could step in and do something similar to what it did for crowdfunding, right? Issue a limited type of exemption to permit the market to grow, in kind of the tiering system that they did for crowdfunding.
Yeah, I mean, I think looking at ways that you can build exemptions that make sense, and that, again, allow you to achieve the purposes of the securities laws, but do so in a way that's consistent with the technology, and allows for a little experimentation too, but doing it with investor protections and marketplace protections in place. That, I think, is a really interesting opportunity for us. And we have a lot of tools to do that. We can issue exemptive orders, we can issue no action letters, but unfortunately, to date, we've really been very constrained in the way we've used these tools in this space. So we started off the conversation talking about the special purpose broker-dealer relief, which is out there, again, quite limited. But the staff has also issued several no action letters in the crypto space, really limited in their application, and not really allowing for this kind of experimentation and allowing the technology to show what it can do. So I'm hopeful that Chair Gensler, who does understand the technology, he knows a lot about it, he was teaching about it at MIT, I'm hoping that he will really take this. He's got a lot on his plate, right? So he's got a lot of priorities, but I hope that he will take this chance that he has to really use our tools to build a framework that makes sense where we have the authority to build such a framework.
Mm-hmm. One last question before we turn it over to the audience, just kind of switching a little bit to margin. The country of El Salvador, not too long ago, adopted Bitcoin as its legal tender. So the country now has the dollar as its legal tender and the Bitcoin as its legal tender. The Federal Reserve, which issues rules and regulations with respect to margin, basically says a foreign currency is any currency issued by a foreign country. And under U.S. margin rules, a foreign currency which is freely tradable and has the mark to market is considered a cash equivalent for margin purposes. What are the collateral consequences of countries starting to adopt virtual currencies as their legal tender?
Well, it certainly does raise all kinds of interesting issues, and leave it to you, Gabe, to think of that one. So I'd love to hear your thoughts on what you think is going to happen now that El Salvador is using Bitcoin as legal tender.
Well, one of the interesting things, it's got to be issued by the country. So I think that's a little bit gray. But what you really have is the fact that you now have that a virtual currency, which it could be considered currency equivalent to a U.S. cash for margin purposes. So could come under the protections of SIPA, could be used to post margin for securities purchases, could be used for like non-purpose credit type of transactions because it's considered a currency, not a digital asset, not a security. There's all kinds of collateral consequences for when you go down the path of being considered a legal tender. And I think there's just more that could come out. And then one of the questions I have: what about the loan transactions? How does that affect these loan transactions and the arbitrage if it's considered a currency, not an asset similar to gold? So just lots of interesting questions come up. So this just goes to show how kind of this market is just constantly developing and will continue to develop. And going back to your point earlier, Hester, is we have to be, I think, a little more creative. I think it's we can't just do we need a different framework for a digital asset than we currently have under the securities framework. So.
We do, and I should say that all of these issues are very much still being worked out. Someone's asking about SIPA applying to El Salvador. SIPA is a U.S. law, so it's U.S. focused, and I think there are going to be a lot of questions around the technical details of how these things apply, which is part of the reason why we at the SEC have been slow, because when you make a decision, it has all kinds of collateral implications, no pun intended. So we do have to be careful.
Yeah, and then going back to the SEC, or many from the SEC have made a lot of comments saying that most of the digital assets they see are digital asset securities, and then SIPA has taken the point of view that it's a security, but not a security entitled to its protections. Cash actually has a separate protection under SIPA, going back to the point. So would a Bitcoin be considered cash for the SIPA purposes? These are things I think still. And by the way, if it was considered, it would offer a certain amount of protection of up to 250,000 per account. So, but let's turn it. Yes, these are all just so many interesting things just are going on in this market, and I think there's just, as the developments occur, more and more questions will come up, and I just think we got to be a little more flexible. And I know you are. You're deeply promoting the industry, and with all of your releases.
Well, and I should be careful to say I'm not promoting any industry. I do promote flexibility, and I think innovation is really important in our financial markets, unless we want to allow the financial markets to become dominated by a few big players that are never unseated. And that's not good for investors, right? We want to make sure that our markets are dynamic. If the incumbents are doing a good job, they can stay and keep doing that job. But if someone else comes in and has a better way of doing things, we need to make sure that the regulatory doors are not the ones that are keeping them out and preventing them from doing that. And so one of the things I find particularly interesting about the crypto industry is that you have people who are thinking about the financial services industry with new eyes, with a fresh way of doing things, and therefore can potentially address some issues in the industry that in ways that might be effective. So whether that's, you talked about democratizing access, whether it's leading to more resilience of the system because you've got faster settlement, whatever it may be, there are potential benefits of the technology, and I want to make sure that whatever our rules are in place, we're not foreclosing those benefits from being realized.
Yeah, no, I should have said yes. You've shown incredible flexibility and guidance as to how things could improve, and obviously the innovation has incredible. You could actually at some point see getting to the use of a blockchain, getting to a T0 settlement, right, for the securities market, which would be I think impossible under the current technology we have. And if you did get down to a T0, I suspect that you wouldn't have kind of the issues that came about because of the meme stock situation. So the technology really, besides its use as a token, but the technology itself can have incredible benefits as a whole. So I think we only have we were trying to leave 15 minutes for questions, and I think we're down to like about 5 minutes. I don't see any questions.
I do see some, but I'm trying to enlarge them so that I can actually read them. What is Congress' position with respect to digital assets timeline to regulations? Well, that's a $1 million question, right? Congress is certainly more and more engaged on crypto questions, and they're doing a lot of thinking about it. I think we're going to see Senator Lummis has announced that she's going to drop a bill on crypto issues, but Congress is doing a lot of other things too, and so it's hard for me to predict when they'll be able to get something through on crypto. In the meantime, regulators are regulating as they do, and they're doing that through enforcement, and I think we'll be looking for ways to do it, I hope, through regulatory guidance, as we've been talking about. So hard to know what's going to happen. I think this year will be a very interesting year to watch both the regulators and Congress. Then there's another question about any limitations for exchanges if they had to register with the SEC. How long would this process take? I mean, that's an excellent question, and that's been one of my I would say pet peeves around this idea of come in and register with us, because crypto exchanges do not look like our traditional securities exchanges. They're actually holding customer funds themselves. They're holding customer assets themselves. And so we would have to think about providing some exemptions to allow them to register. let alone the question of, what do we do if we have a crypto exchange that trades digital asset securities alongside digital assets, because we're not used to having exchanges registered with us that are trading things, non-securities and securities side by side. So I think if we're going to do this, and again, Congress may tell us not to do it, but if we're going to do it, we have to think through some of these hard questions. It's not going to be just an easy route to registering. Probably, I think probably they would register as ATSs, but that there are a lot of questions to be asked around that and answered. And then we have another question on how closely are private crypto native companies working with regulators? Are they showing a willingness to work with regulators? I think that I've talked to lots of people in the crypto space who are very willing to work with regulators. Indeed, when I was working on my safe harbor that I mentioned earlier, I talked to lots of folks. They were very eager to try to think through issues with me, to provide guidance. I put it out on GitHub, and I got people who were actually rewriting pieces of it and suggesting different ways to do things. So I've found a real openness to working with regulators. The problem is that we've told people, come in and talk to us and we'll work with you. But that process is a really long process. And as I said, sometimes what comes out at the other end is a no action letter that is so constrained as to be not very inspiring to other people to come in and talk to us. I see we have another question under the SEC. Are US-based businesses that issue utility tokens and exclude US and Canadian citizens from participating, do they fall under the SEC jurisdiction and subject to SEC enforcement? Jurisdictional questions are very difficult, but I should say that if there's any link at all to the United States, it's very likely that the SEC could assert jurisdiction. We have lots of things that we could spend our resources on. And so one of the things I think about when I think, should we be bringing a case in a particular area is this a good use of our resources? Or is this primarily the CFTC's issue, or is it primarily a foreign regulator's issue? So we think about those things, but given the way the global financial world works, many things have some kind of a tie to the United States. So it is quite difficult, for example, to geofence so that you block US persons from participating, though lots of projects now, as I mentioned, are trying to do just that to avoid potential enforcement in the US. I think that's all the questions that I see. I don't know, Gabe, do you see any others?
I don't see any questions, and you actually broke up for some reason. You went dark for a few minutes, but as you started on that question, it really got me to think a little bit about Rule 15A6, right, which could be used to go after entities who are doing transactions abroad, which can impacts U.S. Citizens, or U.S. citizens are using an exchange or overseas broker dealer. And the Rule 15A6 is a complicated rule. It's I look at it as an incredibly long-arm jurisdiction type of rule, and compliance with it is difficult. And historically, the position has been maybe one transaction is you can do it, but if you have a series of transactions, you could come under U.S. jurisdiction from abroad.
Yeah, I think
how you advertise, that the non-solicited part of Rule 15A6 has really been limited in how it's interpreted.
So I think Gabe's point really illustrates the breadth of U.S. regulatory scope. Let me just quickly address, I know we're out of time here, but a question came in here at the end about a rule proposal that we actually put out yesterday that deals with ATSs, alternative trading systems, and communication protocol systems. And the question is, could it potentially cover DeFi? And I guess I'm glad for the question, because I think it's really important for people in the crypto space who are operating any kind of, or planning to set up any kind of trading venue, whether it's DeFi or CeFi, to take a look at that release. It's really daunting. It's a very long release. but please take a look at it with an eye toward thinking about how it might apply, and please consider helping us think through those issues by writing a comment letter. Among other things, that rule proposal would redefine exchange. So it's really important to get engagement from people all across the industry, whether it's in crypto or traditional markets as well.
Well, Hester, thank you very much for your time and your insights. We all greatly appreciate it.
Well, Gabe, thank you. It's been a pleasure, and thanks to everyone. I hope you have a wonderful rest of the conference.
It's been my pleasure. Take care. Take care, Hester.